This is Radio Entrepreneurs, and we are airing on all your mobile devices from our offices in 119 Braintree Street in Boston. And our next guest is our litigation reporter, Mark Furman, from the firm of Tarlow, Breed, Hart, and Rogers. Welcome, Mark.
Hi, Jeffrey. Great to be with you.
Great to be with you as well. Mark, you're always trying to keep us informed on entrepreneurial issues in the law. What's the important topic our listeners need to be aware of today?
Well, a huge topic in the news for months has really been the Demoulas family dispute and this incredible series of events where employees have literally not worked. Thousands of employees in support of Arthur T. Demoulas, who was deposed as CEO of Demoulas Supermarkets, which he had operated for many, many years, decades, really. And in the employees are so loyal to him, and he was deposed by a group led by Arthur S. Demoulas, his cousin. And basically a switch in support has led to 50.5% of support for Arthur S.'s position and only 49.5% for Arthur T.'s position. That led to him being terminated as CEO.
And do you remember what maybe I'm off track for you. Do you remember the grounds for him being dismissed?
It was just there were claims made that unhappiness over how he was running the company. I think there was unhappiness over distributions to shareholders, but ultimately I think it was it's a power struggle, a family conflict that has existed for decades, which has been the subject of at least 5 decisions of the Supreme Judicial Court.
And going back to his parents' generation.
Yes. And
that's where it all started. That's where the feud.
Yes. I do handle a lot of disputes among business partners. And, this is a seminal case, a very long seminal case in the obligations of co-owners to each other.
And it's not when you say seminal case, I want to be clear for those listening. It's not just a case for the Demoulas family. This is a case that's setting a lot of precedents with a lot of family businesses, which are the majority of businesses in Massachusetts.
Yes.
Because it has been, for me, a regular discussion within the confines of a family of not wanting to go down the Demoulas route. That's the term.
That's right. And it's not just, Demoulas is a family business, but the issue of obligations to co-owners comes up in every business. And the obligations in Massachusetts in closely held, privately owned companies where there's a limited number of stockholders or owners, which are the vast majority of businesses in our state and in our country. The Demoulas case sets forth the legal obligations that partners owe to each other. We have a rule in Massachusetts that if you're an owner of a business and there's another owner, you each own obligations to the company for sure if you're directors and officers, but if you're shareholders or members, if it's an LLC, you owe fiduciary duties to each other. So
right.
Courts treat you as partners. So if you and I are partners, Jeffrey, I am not allowed to let my personal self-interest dictate my conduct regarding you. If we're partners in developing real estate, for example, and I become aware that there's a piece of real estate over in Newton, Massachusetts, that I think is a good development opportunity, I may have the obligation to come to you with it.
Right.
And say, Jeffrey, I found this opportunity. I can't do it with my brother or my sister, I may have to bring it to you unless our written agreement says you and I are only developing this one property. But if we have kind of the boilerplate in our agreements that say we're in the business of developing real estate, I need to come to you and decide whether you want to do it. And one of the lessons of Demoulas is I cannot give you half the story. I can't give you the wrong information. I can't discourage you from investing by making it sound like a more difficult business opportunity that it is.
And
I
this-
have to be forthright and honest to you.
And this becomes so difficult because in a family business, generally speaking, the rules of merit are redefined. And when you're trying to run a business that are not based on the rules of merit, the rules of information change as well, because that flows down and it changes the way people interact with each other. And that casualness may start to dominate a business, but casualness is not the rule of business when it comes to court.
That's true. And everything gets put under a microscope with the benefit of 50-50 hindsight. But, most privately owned companies operate in the context where there are no outside directors, for example. There aren't any disinterested directors when there turns out to have been a dispute between the owners. In a situation where you have a disinterested board, the world is different because, they have their own, disinterested directors have their own fiduciary duties to the company, and they operate as a check, but they also operate as a way of protecting individual shareholders from corporate actions. One of the problems in the Demoulas case is Telemachus controlled everything. So if he decided that something was a good deal, transferring an asset for $3.2 million, which was worth $17.3 million, there was no check on him. So that was certainly a major factor in his being found liable for that was one of the things that he was determined to be liable for, a transfer of assets without fair consideration